तो विपक्षी टाल मटोल की नीति अपनाकर परिवादी का रुपया अभी तक भुगतान नहीं किया था। कहता है कि तुम अपना रुपया भूल जाओ, क्योंकि मेरी जान पहचान बड़े बड़े अधिकारियों से, तो ज्यादा बोलो।
तो वो सब छोड़िए, वो सब कुछ नहीं है।
टू रन दिस
इन एवरी बिजनेस यही होता है।
लॉर्ड,
यू हैव नॉट इवन सेड दैट यू वेंट टू द पुलिस स्टेशन, जो नॉर्मल एक कम से कम वकील लोग लिख देते हैं एक पैराग्राफ कि हम गए और थाना में और लेने से इनकार किया, वो भी नहीं है पैराग्राफ आपकी।
एफिडेविट भी नहीं है,
एफिडेविट भी नहीं है। यस,
placing of FIR, my lord, which was based upon a complaint and which was directed, my lord, by the learned citizen for institution of FIR under section 156(3) without complying the mandatory provisions of.
अच्छा, एक मिनट, जस्ट a minute. So FIR has been lodged without following 154(3) and 156(3).
That is the, my lord, issue involved in this matter, my lord. Apart from that,
Then how FIR has been lodged?
by, my lord, giving a direction passed by the learned magistrate, my lord. And besides, my lord, the
My state has given direction on the petition of the complainant.
My lord, complainant, my lord, filed a complaint for, my lord, institution of wherein a prayer was made for sending the complaint for institution of FIR, and without, my lord, complying and without, my lord, looking into the matter, it was sent in a mechanical manner. My lord, may kindly see the even from the complaint, my lord, no offence is made out. A simply pure commercial dispute, my lord, with regard to payment of share in the alleged partnership. That is the main issue, my lord.
Come to the FIR.
My lord. May I read, my lord? It starts from page 15, my lord. यह कि परिवादी भारतीय, my lord, page 15, my lord.
Yes.
Last two line. यह कि परिवादी भारतीय वायुसेना से अवकाश प्राप्त सेवानिवृत्त है तथा कानून को मानने वाला सज्जन व्यक्ति है। यह कि परिवादी एक कार्यालय स्थानीय फ्रेंड्स कॉलोनी रोड नंबर 2 के विपरीत पनेशिया इंटरप्राइजेज के नाम से मार्च 2007 से चला रहा है। यह कि विपक्षी उपरोक्त कार्यालय में आकर परिवादी से आग्रह किया कि विपक्षी सिक्योरिटी एजेंसी चलाने हेतु DGR रक्षा मंत्रालय से स्वीकृति करा चुका है तथा पटना में अपने प्रतिष्ठान के लिए परिवादी के साथ मिलकर सिक्योरिटी सर्विसेज का काम परिवादी के प्रतिष्ठान के माध्यम से करना चाहता है। साथ ही साथ परिवादी को प्रलोभन भरी बातों से कहा कि आप मेरे साथ काम करेंगे तो परिवादी को भविष्य में आर्थिक फायदा होगा। यह कि विपक्षी के बातों पर विश्वास कर परिवादी अपने प्रतिष्ठान के माध्यम से विपक्षी के साथ मिलकर काम करने को तैयार होगा। यह कि परिवादी और विपक्षी मिलकर सिक्योरिटी एजेंसी के नाम से काम करना प्रारंभ कर दिए। यह कि विपक्षी के कहने पर परिवादी ने 12 लाख रुपया उक्त कार्य में पूंजी के रूप में लगा दिया। यह कि विपक्षी उपरोक्त कार्य की आमदनी में हमेशा अपने शेयर से ज़्यादा रकम ले लिया करते थे तथा परिवादी का लगाए गए पूंजी और मेहनत के मुताबिक आमदनी नहीं मिला, जिसके कारण परिवादी उपरोक्त कारोबार से अपना शेयर वापस करने का आग्रह किया। विपक्षी परिवादी दिनांक 28/7/2014 को मिलकर सिक्योरिटी एजेंसी का हिसाब चेक किया तथा हिसाब करने के बाद परिवादी का 18,80,000 रुपया मात्र पाया तथा विपक्षी ने परिवादी से शेयर को वापस कर सिक्योरिटी एजेंसी समाप्त करने का वादा किया।
Yes, you are for this other side. For the informant. क्या बहस है आपका?
Lord, this is not the matter of accountancy only.
Then?
Lord, the petitioner, Lord, took the informant in his confidence, my Lord.
Yes.
Got the money invested in his security agency, my Lord, to run this.
In every business यही होता है.
Lord, and
In
Lord,
every
after
business यही
investment,
होता है.
Lord, he has
कितने
not,
साल आप लोगों ने काम किया साथ में?
Lord, perhaps 2 years.
2 साल
2 years.
2 years, my Lord. Lord, since the date of my Lord work, my Lord, he, my Lord, did not, my Lord, even, my Lord, given, my Lord, the amount invested by the informant, my Lord. And after, my Lord, at the time of, my Lord, start of the business, my
ये
Lord,
कहीं नहीं आपका केस है.
my Lord.
आप देखिए पैराग्राफ 7 में क्या है आपका. परिवादी का लगाए गए पूंजी और मेहनत के मुताबिक आमदनी नहीं मिला.
My Lord.
ये आप नहीं कहते हैं कि आपको मिला ही नहीं कुछ.
My Lord, after that, my Lord,
यू आर सेइंग कि हमको
पारा-
जितना मिलना चाहिए था नहीं मिला.
para 9, my Lord, thereafter, my Lord, यह कि परिवादी जब 3 माह का समय बीतने के बाद भी विपक्षी से दुर्भाग्य का संपर्क किया तो विपक्षी टाल मटोल की नीति अपनाकर परिवादी का रुपया अभी तक भुगतान नहीं किया। तो यह कहता है कि तुम अपना रुपया भूल जाओ क्योंकि मेरी जान पहचान बड़े बड़े अधिकारियों से, तो ज्यादा बोलो।
तो वो सब छोड़िए, वो सब कुछ नहीं है।
मिलॉर्ड, मिलॉर्ड द मैटर मिलॉर्ड सिंस मिलॉर्ड
तो इतना जो सूट फॉर रेंडिशन ऑफ अकाउंट्स और ये सब जो होता है,
देयर
तो होना ही नहीं चाहिए।
Lord, he has Lord breached the trust, Lord. Since Lord investment was made, Lord, and therefore thereafter, Lord, to grab the amount, Lord.
It is not a case in which a criminal case will lie.
लॉर्ड यह कि परिवादी को पूर्ण विश्वास हो गया विपक्षी ने जानबूझकर धोखा देने की नीयत से गलत कागजात
वो
के
सब
आधार पर
ऑर्नामेंटल लैंग्वेज है, वो सब ऑर्नामेंटल लैंग्वेज है केस बनाने के लिए।
लॉर्ड द मैटर वाज
सब्सटेंस क्या है? एलिगेशंस आपका एज इट इज।
द मैटर वाज इन्वेस्टिगेटेड लॉर्ड एंड द चार्ज शीट हैज बीन सबमिटेड लॉर्ड whether he has committed an
चार्ज शीट हैज बीन सबमिटेड।
Cognizance has not been taken, my lord. till
चार्ज शीट हैज बीन सबमिटेड लॉर्ड।
हाँ, बट इसमें तो है इंटरिम ऑर्डर है। देयर इज एन इंटरिम ऑर्डर ऑफ दिस कोर्ट।
चार्जशीट के बारे में मुझे इंस्ट्रक्शन नहीं है, वेरीफाई करा लूँ।
इसमें देखिए 7/11/17 को इंटरिम ऑर्डर है।
7/11/17
And even this complaint case was not fit to proceed. कंप्लेंट आपने जो फाइल किया उसमें आप देखिए ना, कहीं है आपका कोई स्टेटमेंट?
Complicity of the Milord, the petitioner Milord.
You have not even said that you went to the police station, जो नॉर्मल एक कम से कम वकील लोग लिख देते हैं एक पैराग्राफ कि हम गए और थाना में और लेने से इनकार किया, वो भी नहीं है पैराग्राफ आपकी।
एफिडेविट भी नहीं है,
एफिडेविट भी नहीं है।
Lord, I will verify it whether the charge. But Lord, I have stated in my counter affidavit, Lord, that the charge sheet has been submitted.
Maybe लिखिए heard land counsel for the petitioner and land counsel for the informant.
I appealing for the state.
As also Mr. Ajay Kumar Sharma, learned AC to AG for the state. Petitioner in the present case is seeking quashing of the first information report, para 1. Land counsel for the petitioner submits that on a bare perusal of the first information report, together with the
May I submit one thing more?
copy of the complaint petition,
If your losses permit, Lord, there is no pleading in the entire petition, my Lord, that the informant has not filed the affidavit, my Lord, or there is compliance of the, my Lord,
all right,
156.
all right, I'll take note of it. क्या लिखा?
Learned counsel for
बैठ जाइए 2 मिनट आप लोग। Yes.
Learned counsel for the petitioner submits that on a bare perusal of the first information report together with the copy of the complaint petition.
Complaint petition being complaint case number 2221 of 2015, which is the basis of lodging of the FIR, it would appear that the opposite party number 2 moved directly to the court of learned Chief Judicial Magistrate Patna by filing a complaint petition. Full stop. In the complaint petition, there was no averment at all that the opposite party number 2 had approached the jurisdictional police station or had followed the procedure as prescribed under section 154 within bracket 3 CRPC. Full stop. The complaint petition was not even supported by affidavit. Comma still. On the oral prayer of learned counsel for the OP number 2, the learned CGM directed learned CGM forwarded the copy of the complaint case to the SHO of Shastri Nagar Police Station, Patna, to investigate the matter. Full stop. The SHO of the police station registered a first information report. Full stop. Next, relying upon a judgment of the Honorable Supreme Court in the case of Priyanka Srivastava, so and so, Land Council submits that the very lodgment of the first information report would be in the teeth of the judgment of the Honorable Apex Court. Full stop. Next, it is further submitted that on a bare perusal of the allegations made in the complaint petition, it would appear that both parties were running a security agency under partnership. Full stop. The allegation of the complainant is that on the representation of the petitioner that both of them will work together and from that work they will derive good benefit, good income, the OP number 2 had agreed to start the business, and at the instance of the petitioner he had invested a sum of rupees 12 lakhs as capital. Full stop. It is further alleged that during the continuance of the business, the OP number 2 was not given his due share.
Respondent number 4.
Respondent number 4 कर दिएगा सर. Was not given his due share, and the petitioner was always withdrawing more than his due share. Full stop. In this regard, the respondent number 4 is said to have requested the petitioner on many occasions, but no heed was paid to his request. Full stop. It is lastly alleged that on 28/7/2014, the accounting of the security agency was done, and the petitioner was found entitled to, and the respondent number 4 was found entitled to receive a sum of rupees 18,80,000. Full stop. It is then alleged that the petitioner promised to return the amount and liquidate the security agency. But despite lapse of 3 months' time and repeated contact over telephone, the petitioner did not pay the amount. Full stop. The allegation is that when the respondent number 4 contacted the petitioner, he was abused and beaten. Full stop. Land Council submits that the allegation of abuse and beating is nothing but an ornamental allegation against the petitioner. Full stop. No such information was ever given to any police station by respondent number 4. Full stop. Land Council has relied upon the judgment of the Honorable Supreme Court in the case of Bhajan Lal, so and so, and Inder Kumar Goswami, 2007-12 SCC, page 1. Full stop. It is submitted that without adding or subtracting anything out of the complaint petition, it may be easily concluded that a pure and simple civil dispute has been given color of a criminal proceeding. Next. On the other hand, Land Council for the respondent number 4 has opposed the application. Full stop. It is his submission that right from beginning, the petitioner had no intention to pay the due amount of the respondent number 4. and he was acting with an intention to cheat. The respondent number 4, which ultimately resulted in the misappropriation of the huge amount which became due to the respondent number 4 on final accounting. Full stop. Next, it is further submitted that as regards the non-observance of the procedures under section 154(3) and 156(3) in terms of the judgment of the Honorable Supreme Court is concerned, this plea has not been taken by the petitioner specifically in the application. Full stop. Next, client counsel for the state has आपका कोई submission अलग से?
In the light of CGM order, my lord, FIR has been considered.
Learned counsel for the state submits that in the light of the order of the learned CGM, the FIR has been lodged. Next, having heard learned counsel for the petitioner, learned counsel for the informant as respondent number 4, and learned counsel for the state as also on perusal of the complaint petition, this court is of the considered opinion that the FIR has been lodged without following the mandatory requirements of law in terms of the judgment of the Honorable Supreme Court in the case of Priyanka Srivastava within bracket Supra. Full stop. The submission of learned counsel for the respondent number 4 that no such a specific plea has been taken in this matter would not impress this court, as it appears that a party to the proceeding may always cite a judgment of the Honorable Apex Court and point out the mandatory nature of the requirements which is to be followed by the informant. Full stop. This court further finds that this point was taken by the petitioner as back as on 7/11/2017 when the learned court, when this court passed an interim order. Full stop. Next, this court has also perused the complaint petition and finds that both the parties were in a partnership and they were running the business of security agency. Full stop. It is not the case of the respondent number 4 that he was not at all paid his remuneration or share. Full stop. His grievance is that he was not being paid his due share in terms of his capital and labor. Full stop. If this is the only allegation against the petitioner, that he was not paying the due share to the respondent number 4, this would be a case of pure and simple commercial dispute which will be guided by the law on this subject. Full stop. By no stretch of imagination, it may be said that it will give rise to a criminal proceeding. Full stop. In the case of Inder Kumar Goswami, in paragraph so and so, the Honorable Supreme Court has observed thus. Quote, next, in the case of Bhajan Lal, in bracket Supra, the Honorable Supreme Court has laid down the category of cases in which the power under section 482 may be exercised. A power for passing of the FIR may be exercised. Full stop. The relevant part of which is being quoted here under for a ready reference. Next, In the totality of the circumstances, the materials available on the record, this court is of the considered opinion that further continuation of the criminal proceeding against the petitioner would only be an abuse of the process of court. Full stop. In the ends of justice, this court therefore quashes the first information report as well as the subsequent proceeding, if any, against the petitioner. Full stop. This application is allowed.